The court calls the matter of Schroeder versus Swanson, case number 2019-6353 DC. All parties and attorneys could please state their name and appearance for the record, starting with the plaintiff's attorney, Ms. Town.
Good morning, Your Honor. Gail Town on behalf of the plaintiff, Corey Schroeder, who is also appearing via Zoom today.
And Mr. Schroeder is here appearing by phone. Your name?
Corey Schroeder.
Okay. And Nancy, your name for the record?
Nancy Taggart.
Good morning, everyone. Excuse me. Today's date and time set for a hearing. This matter is being done by remote technology. The contents of this video may be the official record of a proceeding of the state of Michigan's 9th Judicial Circuit. Unauthorized duplication, distribution, or alteration of said content is strictly prohibited. Today's date and time set for an objection to referee's recommended order. It was done on June 9th. Ms. Taggart, I've read your objection in the order of referee Leo. What are you asking for, Ms. Taggart?
I'm asking that there not be any child support order.
Okay. Okay, and is a lot of that is based on past actions between the parties, is that correct?
Yes, we had an agreement that there would be no child support order in the custody agreement as long as I kept up her health care and dental insurance.
Okay, is that in writing in a court order somewhere?
Yes, it's in the original custody agreement, September 9th, I believe, of 2019.
Okay. Ms. Town, does your client disagree with that?
We'll have to ask my client, Your Honor, but from my last, it wasn't entirely clear to me exactly what Ms. Taggart was asking for in her objection. I believe my client is agreement with the referee's recommendation and that there be child support at this point in time. Mr. Schroeder,
Okay.
You can, if the
Mr.
judge
Schroeder,
wants
is
to.
that your understanding?
Yes.
Okay, I'm looking at the September 2019 order. It says no uniform child support shall be entered at this time as the issue of child support is hereby reserved for the reasons set forth on the record. Defendant mother will look into cost of her employer provided health care insurance and she shall provide the information to the plaintiff's attorney. Okay, that really doesn't tell me that there will be no child support order for eternity, but I can review the tape of referee Leo and look at prior orders of this case and we could set this matter for a hearing. But ma'am, the only thing you're asking for is no child support, correct?
The child is 16 and a half. If she doesn't want to see me, I'm not going to force her to see me. But Corey did not pay child support for 14 and a half years, not a dime. And now he's coming to me asking for child support, which is ridiculous.
It may be ridiculous. I don't know the past history, but even if it's at the history, he has a legal right to seek child support, and the referee had a hearing and ordered child support, but you want me to review that hearing and make a decision. Is that correct?
I would, but I would also like you to consider that there is no extra out-of-pocket cost to him just because she isn't coming here on the weekends. He's no longer driving her back and forth, which saves him money on fuel and time. His parents are the ones paying for everything because she does not even live with him.
Okay, that
So
doesn't factor in the child. Okay.
He's asking for child support for a child that doesn't live with him.
Okay, that does not factor into the child support as long as the child's living with him. You're claiming the child doesn't live with him?
She does not live with him. She lives with his parents.
Okay, well, we'll set it for a hearing. I'll review the tape and I'll allow any additional evidence that the parties may have and witnesses. I think a 2 hours should suffice. Ms. Town, any problem with 2 hours?
You're saying you're setting a 2-hour hearing for child support?
Yes.
Okay. Yeah, I'm not sure that we would even need that amount of time.
We usually don't, but if she's claiming that the child doesn't even live with father, I'll allow her to present evidence with regards to that.
There's evidence in all the previous court papers.
Okay, ma'am, let me make my record before you interrupt me, please. So I'll allow her to present it. Taggart, you may perhaps, we'll set it for 2 hours. Does that work for you?
Sure.
Okay. How many witnesses do you think you'll have, Ms. Taggart?
I would like to call both of his parents, Montana and him.
Okay, well then you have the obligation to subpoena the witnesses you want and provide witness lists. Both parties will provide witness lists 2 weeks in advance and any exhibits 2 weeks in advance. But I hope this isn't a goose chase, or I will reserve on attorney fees. But everyone has a right to object. But if I'm going to set it for a 2-hour hearing, Ms. Taggart, I hope you have presentable evidence that is legally admissible.
I don't know what you mean by reserve attorney fees.
That means if I find that you're just wasting everyone's time, I'm going to make you pay his attorney fees.
I'm not trying to waste everybody's time. I'm trying to, I only agreed to custody because I wouldn't have to pay child support. And now they're coming back after me for child support. I think I have a right to fight this.
You have a right to fight this, but if you show up with no witnesses and no evidence, then I reserve on attorney fees.
Great, thank you.
Okay, so we'll get a 2-hour hearing date. I'll review the testimony. I will let both parties know what the referee decided. I may do exactly what the referee did. I may do what Ms. Taggart wants. I may do what Ms. Schroeder wants. I may do something completely different based on the evidence I hear. So we'll get a 2-hour date set.
We can do September 3rd at 9 o'clock.
I will be out of town.
Okay.
I don't have that available either. I have a couple of questions, Your Honor, I just wanted to clarify what you stated on the record, if you don't mind.
Sure.
You indicated that we would exchange witness. What did you say about 2 weeks in advance? We would exchange witness lists?
Witness lists and any possible exhibits 2 weeks in advance.
Does that go just to the court, or also do I have to send copies to the attorney?
Send copies to the attorney and she'll send you anything.
In the mail, correct? I don't want any emails, just mail.
We can do snail mail, that's fine.
Thank you.
And then, Your Honor, I think I heard Ms. Taggart say she was calling the minor child Montana as a witness.
Who are you calling, ma'am?
Yeah, I'm calling the minor child.
Okay, what reasons to call a minor child in this case?
Because we haven't heard a word from her. I haven't seen or spoken to her in over a year. But he's
Okay,
putting words in her mouth. Don't call the minor child, fine. Let's not call the minor child.
Okay, so now you're not going to call Montana?
No, but I will be calling on both of his parents, his Aunt Debbie and him.
Okay, as long as they're subpoenaed.
Okay.
Anything else, Ms. Town?
No, I think that's all that I had a question about, Your Honor.
Okay, let's get a date.
We can do August 27th, 9 or 10.
I can't do it that early if I have to subpoena all these people and get court papers in.
Okay. All right, how about October 1st then? We have either 10 o'clock or 3 o'clock.
3 o'clock, October 1st.
Unless this has been adjourned, I have another trial with you that day, Your Honor.
Oh, yeah, you do. Can you do 9 o'clock?
No, I have a hearing in front of Referee Noble.
Okay. October 15th, we have 1:30.
I'm fine with that.
I'm sorry, I don't have that either. I'm sorry.
It's okay.
October 20th, we have all afternoon available. We do 1:30 or 3.
I have a trial on my calendar with Pierangeli that afternoon. Was that one adjourned, Carlia?
Rapid?
Yeah.
That's settled.
It's not settled.
Oh,
No,
no, it's adjourned.
okay,
It's-
adjourned till
okay.
November
It was
16th.
adjourned.
Okay, we might not have just updated my calendar on that one yet. I know we were
Okay.
trying to adjourn it. October 20th, you said,
Yes,
at 1:30?
yes.
Okay.
Does that work for Ms. Taggart?
Yeah,
Okay, October 20th at 1:30, you want by Zoom?
By Zoom, and all prior orders remain in effect. Any questions by anybody?
no.
Oh,
Okay, I'll review the tape of the previous referee's hearing and the court file, and we will be ready to go on October 20th at 1:30. Thank you, folks.
Thank
Thank
you.
you, Your Honor.